Hi, it's Caitlin Jenkins here, the family law vlogger. This is the next in the stages of divorce series, and this one is about completing the Form E and section 4.4, which is bad behaviour or conduct section. Now, this is a really tricky section, and there's often a big difference here between what clients want to complete in this section, what their solicitors will advise them to complete, and what a court would actually want to appear in here. Now, the context of this is that the statute says that when looking at the finances on divorce, there's a statutory list of factors that the court will take into account. And there's also the overarching factor, which is all the circumstances of the case. And then there's a list of factors which the Form E is designed to bring out. Now, one of those lists of factors is bad behaviour or conduct if it is so bad that it would be inequitable to disregard it. Now, to most lay people, that means may well mean that they would like to include in this section because they feel it will be relevant what behaviour has led often either during the marriage or has led to the breakdown of the marriage, whether that's behaviour around adultery or unreasonable behaviour of some other type or domestic abuse or all those sorts of types of rationale or the reasons that one person feels is the reason for the breakdown of the marriage. Now, the court broadly takes a different view, and this really is a topic area that if you want to include something in your Form E that you should take advice on. But the court takes a different view, and the case law is such that it's only very extreme behaviour that the court will take into account when thinking about the division of finances on divorce. And it's likely to be not behaviour around the personal side of the relationship that's led to the breakdown of the marriage. It's likely only to be extreme versions of financial behaviour that may therefore be relevant to the financial circumstances that a court may take into account for the future. Now, even if there's financial behaviour, for example, one of the couple has spent a lot of money on gambling, or one of the couple has been quite profligate in their spending post-separation, or one of the couple has been very secretive about the finances. Those are all the sorts of things that sometimes people think should be included in the form or that section of the form, and it may be relevant to do so. But a word of warning, the case law is such in this topic area that it is only very extreme versions of financial misbehaviour, which one of the cases described as had to be wanton and reckless. So really very extreme that a court will think is relevant to or may consider to be relevant to the financial considerations around what the financial arrangements should be going forward on divorce. So winding back to section 4.4, given that it's only behaviour of this extreme and broadly financial nature that a court is going to be concerned with, you really need to give some very careful thought as to what is relevant to include in that box. And it's unlikely to be around the behaviour during the marriage or the treatment or the cause of the breakdown of the marriage. It might be, but it's very unlikely to be. So a word of warning really about this box, on most Forms E, this box is empty because the court is not going to be concerned about how the couple have got to this stage. They're going to be concerned about finances and what the finances are and what the law says for the financial arrangements for the long term. So if you think that there is a key area that needs to be included, and if you are sorting this out through solicitors or completing this for your solicitor to have a look at, then my advice to a client would always be fill it in, let me have a look at it. But really, in terms of what you should be expected to will be regarded as relevant from your solicitor, from a court, it's likely to be quite different to what the layperson would expect to include. So as I say, difficult topic area, one of the hardest areas, and an area on which you're likely to need some specialist advice. So that's section 4.4. The next vlog will be dealing with the final section of the Form E, which is 4.5. So watch out for that vlog, which is coming soon. As always with the vlog, I can only give general information or background thoughts or my thoughts from experience on particular areas on the vlog. If you need advice on either 4.4 of the Form E, the behaviour or relevance of conduct generally, or on any topic area of family law, then feel free to contact me or one of the other members of the children and family team at Specialist Family Lawyers Mills Reeve, and we'll do our best to help you. Thank you.